The next case that comes before the court is Quill versus Sengupta. Good morning, counsel.
Good morning.
I guess 1 minute yet that we can say good morning. The court has received the documents, read the briefs, ready to proceed. Are both sides ready to proceed?
Yes, sir.
You have 15 minutes each, and the appellant may reserve up to 5. Thank you. Just let me know how much time you want to reserve.
Your Honor, if it please the court, my name is Kenneth Cahill, and I represent the appellant in this case, Patrick Sengupta, and I would request that I reserve 3 minutes on rebuttal.
Thank you.
In this case, there are two errors I bring forth. I would submit to this court there has not been a de novo review in this matter. A transcript was filed, and objections were filed within 14 days. I will start with more of an argument on the merits of the issuance of the CPO. I believe the court was mistaken in issuing the CPO. When they were faced with facts such as my client had in March of 2014 jabbed his wife in the side when they were on an airplane ride during her pregnancy, and he had left a bruise, and that just at the time of the date of birth or thereafter of the child in September of 2014, that he was very grabby upon her. And yet, the petitioner claimed in early March of 2015 she filed for divorce, and there was no ex parte order immediately removing him from the house, but there was an agreement that he'd stay in the basement and he'd stay in the bedroom. 2 months later, she said, and she claimed he said he would slam me and he was chasing me around the house. And then on May 23, she claims he left a bruise. That seems to belie the fact that on that Saturday night, even though, as she testified, things were getting consistently worse and she was afraid of herself, yet they were both occupying the same room watching TV on Saturday night after the child was put to bed. So I realize, and even in the trial brief of the petitioner, they mentioned that a criminal trial which was held 2 weeks later where my client was found not guilty of domestic violence. I think what the court failed to take into consideration is that there was such the preponderance was not established because there really was conflicting testimony just by the petitioner herself in this case. When she says that things are getting consistently worse, she's a victim of domestic violence, yet on May 23, what does she do? She's sitting on a couch with this person that she says is consistently frightening her, and they're watching TV. And then she claims that he committed domestic violence with his left hand when in the trial brief, when in the brief of appellee, they say on page 6 he used both hands, which is not true. I think the fact of the matter is there should be a de novo review, whether by this court or remand back to the trial court for a new trial.
Well, how would we conduct a de novo review where the trier of fact had the opportunity to view the witnesses and to make the credibility determinations?
Well, just as the judge would have the opportunity to do a de novo review of the transcript, that was not done. The judge signed that, the magistrate's finding that day. So it was only the magistrate that did a review, looked at the witnesses. There was never a de novo review by the trial court, by the judge.
But don't you still defer, I think what Judge Moore is getting at, don't you still defer to the trier of fact who's actually viewed the witnesses and so forth? I mean, obviously, we can make a determination that it doesn't all add up and it's against the weight of the evidence or whatever, but, there still has to be some deference, right?
I don't believe so, not at this point, not with this special statutory proceeding. I believe there has to be a de novo review, as if from the beginning, as if you question that initial trial of fact. This is not where there was a trial by the magistrate, a de novo review by the trial judge, and your rule is now, is there an abuse of discretion? I don't believe that is the case. This court can do a de novo review. This court can look at the transcript and say, you know what? There just isn't a preponderance of the evidence here. There's something on this side and there's something on this side, especially when you had a criminal trial coming up, which is understandable for the respondent not wanting to testify regarding the facts, then being found not guilty. I think that demands that we should now have at least a new trial, at the least.
Well, but the criminal trial, as you know, is beyond a reasonable doubt.
That is true. I absolutely.
So that really shouldn't really impact anything, should it?
Well, I think it should be a factor. And I would ask this court to consider it as a factor when you look at the totality of all the circumstances in this case, when you look at the facts. What happened here when mother wife says, you know, I've been afraid for quite a long time, and this and this and this, and yet her actions dictate, well, I'm not afraid of this man. I mean, even when they had an agreement in the domestic relations court, look, you stay down in the basement, and I'm going to stay up there. What does she do? She violates that order. So by her own actions, she is...
How did she violate that order?
Well, there was an agreement that he would remain in the basement part of the home, and she'd remain...
Did she go to the basement and watch TV with him?
No. He came downstairs. At no time did she ever testify, hey, you got to get out of here.
Well, it sounds like he violated.
Yeah.
But I would suggest that they both violated the agreement, because at no time did a wife ever say, you know, you're not supposed to be here.
Well, she's scared of him, maybe that's why she didn't tell him.
Well, but I would suggest that the following day, when she left, and then she comes back, after consulting with her parents, why would she come back if she was that afraid? Why would she even have put herself in a situation on May 23 when she had consistently said all along, I'm afraid of him?
Well, you know, some of us have spent years on the municipal court bench where we see these issues routinely and have an appreciation for the factors that don't really make sense, like why a woman would really stay there, or when the husband or the boyfriend is arraigned on charges, she's there before the jailers can bring him up saying it's all my fault, and then is back with him. So there are issues like that happen, particularly with couples who are sharing the same home and are supposed to, you know, everybody's supposed to be in their respective corners.
And
It's
Judge
just not neat.
And Judge Moore, I agree with you. But when you look at the transcript, 2 days earlier, on Thursday, May 21, they spent time together. On Friday, they spent time together. On Saturday, they spent time together. My point being is, there's a reasonable argument on both sides. And that's why at this point in time, because the criminal trial, my client testified fully and completely. And that's why I think an argument can be made that these CPOs, maybe in this case, was used as a cudgel against my client for an upper hand in a divorce. We've all seen that as well.
That's right.
So I'm just asking that there should be a de novo review, either by this court or remand back to the trial court, so that there can be a full and complete hearing on this CPO. And I think once that happens, just as we had at the criminal trial, and I agree, it's a much higher standard, I do believe at this point my client no longer has handcuffs on, and he can testify. And first of all, I was not the attorney. I've been the attorney of record on all of his cases, except on this hearing date, Attorney Anna Parisi had to show up. I could not make it that day. I had a prior schedule. At one point, Anna Parisi did ask for a continuance after the case in chief, and she was denied. Initially, she did say she was ready to go. But still, I think at that point in time, there could have been, and I think this court can also review that, to say she only had about 2 hours to prepare. She initially was at the domestic relations court for a pretrial, and then was served with this hearing notice of the full hearing. And then she had to go to the full hearing.
So are you asking this court to rule as a matter of law that any time a party is charged with a criminal offense, that the court should hold off having a hearing on the civil CPO until after the criminal case is resolved?
No, Judge, I'm not. I don't believe there's any.
Thank you for not asking us to move that,
No.
because that could be disastrous.
It could.
But you're saying under the specific facts of this case, in order to give your client now the opportunity, without giving up his Fifth Amendment right, that there ought to be a rehearing.
There should be, because the criminal trial was only 2 weeks away. It was on July 14 of 2015. And it only lasted 1 day, and by the end of the day, we had the verdict, not guilty. So I think there should have been more consideration. I think the trial court should have considered that, and I mean the judge. And I think this court can consider that on a de novo review of that.
Well, that's not an assignment of error.
It is not.
Okay.
It is not, but I do believe that since this is a special statutory proceeding with a de novo review by this court, that is a consideration that you can look at. I would also submit to the court that when you look at the filing of the divorce in March of 2015, and that there was no order by the court that he had to immediately leave the home, at least at that point in time, the trial court was not convinced of any concern that rose to the level that husband had to be immediately ejected from the house. And, as I say, both husband and wife entered an agreement, okay, you're okay down there, I'm up here. Mother could have demanded an ex parte order, she could have moved out, she could have gone to her mom and dad's, but yet she continued, and she had able counsel at all stages, and yet she remained in the home. I would suggest to this court that what she testified to as her fear really wasn't as disconcerting to her as she had thought, or as she had suggested to the court. Once again, with a divorce case just pending 2 months earlier, there is, I believe, a motivation on her part to get an upper hand in this case, which she's had since then. And I would only suggest that a de novo review should be done, if not by this court, remand it back for a full hearing before the trial court. Thank you.
Thank you, Counsel. You may proceed.
Thank you, Your Honors. Ken Gibson on behalf of the appellees. I'm hearing a lot of things in oral argument that I didn't see in the brief, and I didn't see in the, and there's stuff that I'm hearing in the oral argument that wasn't in the record before the magistrate. Magistrate obviously didn't know the results of any criminal proceeding, didn't have the benefit of any of that information, and I'm not sure whether it would have mattered or not, given the difference in the standard of evidence, the burden of proof. But that's not in the record. I mean, there was something filed with the trial court at some point in time, but it wasn't before the magistrate, and it wasn't admitted as evidence, and I don't think even the fact that there was a acquittal at some future point in time is even relevant or before this court.
Well, was it before the trial court, at the time the trial court signed the CPO order? Well, it couldn't have been because it had not taken place.
The actual CPO order, it looked like, was time-stamped on excuse me, July 14th, and that was the day of the trial in the criminal proceeding. So I would guess that it could not have possibly been filed with the trial court prior to the CPO being time-stamped by the trial court. This concept that a husband or that he would have the right, the respondent would have the right to have a de novo review by this court would upset all the jurisprudence that I've seen in this area of case law. Second of all, he had a full hearing. There was an evidentiary hearing. He chose not to testify. That was a choice that he had. He chose not to present any other witnesses or any exhibits. The magistrate heard his attorney cross-examine the witness, the petitioner, at length with regard to the same facts that are being presented to this court. The magistrate said the petitioner presented the most credible testimony. The magistrate believed the testimony, having heard all of these issues. You know, it seems like I'm back in the 50s before people realized what the symptoms and the circumstances of abuse in a domestic context exist. I mean, it's well known, as you indicated, Judge Moore, that a woman in these circumstances does not always act completely rationally. And that there are times when they remain in a situation which they shouldn't. If that were the basis of holding that there was insufficient evidence in this case, I rather suspect that 90% of the cases of domestic violence would not result in a CPO. I mean, that's just not a wise policy decision. It's not in accordance with the law. You know, this person was testified that she was choked, that he had previously chased her around the house, threatening her, that she was in fear of her safety, and that certainly is enough. Even the trial court, in reviewing the full hearing by the magistrate, doesn't perform a de novo review. Under the statute, the trial court on objections looks to see whether or not there is a basis for holding the magistrate's decision as having errors on its face, not being in a proper form, etc. And this trial court found no such things. There were objections. He had the opportunity to proceed on the objections, and if he wanted to have the trial court make a review of whatever the trial court's limited review was, he should have not filed the notice of appeal, which divested the trial court of jurisdiction.
Which reminds me, he also has a motion to remand in front of us.
Actually, it was my motion.
So it's your motion, I'm sorry.
I made a motion to dismiss or a motion to remand because I was unsure whether it was a final appealable order. I know that generally it is, but I had done some research to see whether or not there was case law out there as to whether or not the filing of objections then makes it not final and appealable until the court rules on the objections when he did that. I did not find any case law in that when I filed the motion. Since then, there's at least a decision out of the 8th District that says that the filing of objections and then the subsequent filing of the notice of appeal does not create a non-final order. I double negative, I apologize.
I know what you mean.
But that the objections doesn't prevent the order from being appealed or the appellate court's jurisdiction. There was a dissent in that case, and the dissent said, I agree with the basic proposition that it doesn't deprive us of jurisdiction, but I think the appropriate remedy is to remand. In this case, I mean, I was sitting here for the argument before, and I'm well aware of what goes on in Medina and how long it takes to get some of these objections ruled on. It may well be that this court's going to act a lot faster than the trial court would in making an opinion here. Now, I don't want to
We had,
disrespectful at all, but.
that's all right. We had in our notes that there was, because the panel doesn't necessarily see the pre-argument filings.
Right.
Procedural stuff.
I had
They're handled by different panels and stuff, and yes, and staff and administrative staff. But regardless, the point is, we were aware that somebody had filed that. And so I think it's an issue that the court, as you indicated, that the court has been dealing with. It's obviously 65.1, it's kind of new with some of the nuances, I should say. So the court is dealing with it. So are you still proceeding, or do you want to withdraw your motion?
I'll withdraw it. I think that, I didn't see any ruling in this court, but I think that the better rule is probably to allow it to go forward as a final appeals order, despite the filing of objections.
But you wouldn't disagree that we have discretion to send it back? Or you would disagree with that?
No, you have discretion to send it back if you feel that's appropriate. And I don't have a problem with that. I just know how long it's going to take to get a ruling on it and get back to council.
Thank you.
I think that one point I wanted to make on the appellant's argument, I wrote this down because he said that there's a reasonable argument on both sides of this issue. Well, if there's a reasonable argument on both sides, then he can't meet his burden of proof to show that there was error in the trial court. The deference to the magistrate's decision and the trial court's decision requires that if there's a reasonable argument on both sides, that it's not against the manifest way of the evidence as he has argued. Finally, I'd like to mention that I think the assignment of error number 1 was fully disposed of in the briefs. He didn't argue that. I would just reiterate the arguments that I made in my brief, that Rule 53 does not apply, and that Rule 65.1 is the applicable rule, and that rule was followed. I do note that in the CPO, there was a certification that it was a final appealable order, and that was served on all parties. If you have any other questions, I'd be happy to answer. I mean, the circumstances of this case, if the petitioner's testimony is believed, and the magistrate did believe it, present a very serious situation justifying this CPO, and we think that that decision should be affirmed. Thank you.
Thank you. Counsel, you have your 3 minutes remaining.
Thank you, Your Honor. Your Honor, due to the fact that Rule 65 came out only in 2012, and there has not been a lot of case law interpreting it, I filed my objections on the 13th day after the magistrate issued her decision. I wanted to make sure when I filed the appeal, I also did that in a timely fashion. As my opposing counsel admits, there has been even a dissent in this regarding it, so I felt it best to protect my client on both sides. I did file a motion to remand as well in this case. I would submit on the facts of this case, there were no pictures submitted by the petitioner. There was no hospital report. The police came the next day. They took pictures. She asked no police to testify. She asked the police not to submit any of their pictures in this case. My client only had 2 hours. He was already at the courthouse on another matter. He didn't have any exhibits or any other witnesses to submit anyways in this case.
Did I understand you to say that wife did not ask the police to testify, or did you say that she asked the police not to testify?
She did not ask the police to testify because no
understand.
police showed up.
Okay.
When the
I
police
just
were
want
there.
to be clear.
Sure. So she submitted no testimony from police officers. She submitted no pictures from the police who were there within 12 hours of the alleged incident.
Was this the case where there was a photograph taken by perhaps her mother?
Yes.
It was not admitted?
Correct.
Okay. So there was at least an attempt to admit something?
That is correct.
Okay.
And I would suggest that in general, when we talk about symptoms of spousal abuse, I agree. I agree that that is an issue in this country. But I would also ask the court to look at this case. Was there any medical reports? Was there any abuse counselors? Were there any psychological reports? Was there any advocate brought in? Let's look at this case. Is this a case where there was a history of some type of psychological spousal abuse that we should take into consideration? Well, there was no evidence brought forth in this matter. And I would suggest to this court that when I suggested there were reasonable sides on both sides, when you've got a 50-50 split and you just can't make that decision, then you should not issue a CPO. And I don't believe the facts as presented, when you look at all the facts and all the contradictions by the petitioner, I think her case is far less than 50-50. So I would suggest that the court should not have issued a CPO, and at a minimum, there should be a remand for a full hearing back to the court. Thank you.
Thank you. Thank you, counsel. Thank you to both sides for your arguments here today. The court will take the matter under advisement and issue a written opinion to be sent to both sides, as well as released on our website. Thank you.
Thank you very much.
And the